Hello, everyone. South Carolina Legal Services welcomes you to another episode of Level Up Law, where we bring you legal information to increase or level up your game when it comes to areas of our law practice here at South Carolina Legal Services. I'm Susan Ingalls, Senior Staff Attorney, and I'm delighted to introduce our Housing Law Unit Head here at SCLS, Mark Fessler. He's a fountain of information when it comes to landlord-tenant law. So this proves to be an exciting and excellent presentation, I'm sure. Before we get started, I want to let you know three things. First, all participants will be muted. You can ask questions in the question box, which you should see on the right of your screen, and I will relay those to Mark throughout the presentation. Now, he can't give legal advice, but hopefully he can provide some answers for our listeners today. Number three, all of you who are participating in Level Up Law today will receive the slides from today's presentation as well as a recording. So thanks for joining in, and Mark, take it away.
All right, well, thank you for inviting me to do this, Susan. This is a very important topic, and what we tried to do is just to put together a very basic overview of some of the basic landlord-tenant rights that come from the Residential Landlord-Tenant Act, which is the primary set of statutes that governs landlord-tenant law in South Carolina. And so there shouldn't be anything too convoluted or complicated here, but just wanted to give a very basic overview of some of these issues. The disclaimer, which you already touched on, is this is not legal advice. This is just legal information. If you have a particular circumstance for which you need more nuanced and more detailed legal assistance, you should probably consult with an attorney. You can apply for legal services by calling the 888 telephone number at the bottom of this slide. And the South Carolina Bar operates a referral service. So if you don't you could also go on Google, I guess, and search for real estate attorneys in the local area, but you can also use the referral service if you need to be connected with a lawyer. And this is also a note, a lot of housing programs and projects are covered by federal laws. These are often referred to as either public housing, subsidized housing, low-income housing tax credit. There are a variety of different types of programs. This presentation doesn't cover the myriad of rules and regulations and scenarios that can arise when you're talking about public or subsidized housing programs. We don't have enough time in the hour, perhaps not in the day, to really get into the meat of those programs. So we're just going to focus on what the state rules and the state statutes require as it relates to private landlord-tenant law. Also, just to note that this does not really cover commercial landlord-tenant law. There are some principles of landlord-tenant law going back to ancient England, which have carried over and cover both residential situations and commercial situations. However, the particular statute or series of statutes that we're going to draw from is called the Residential Landlord-Tenant Act, and it was passed specifically to address issues that had arisen with respect to residential landlord tenancies. So first of all, where do the rights that a landlord or a tenant have come from? Predominantly, they're going to come from the rental agreement, the contract. So quite frequently when a client says, can I do this, or can I do that, or can the landlord do this, or the landlord do that, or charge me this or that, my first response is going to be, well, what does the lease say? What does the contract say? A contract is simply a private agreement between two parties that sets forth rights and responsibilities that those parties have. It's often the case that things are left out of a contract. So a contract is not necessarily going to be all-inclusive or comprehensive, but it should hopefully be as comprehensive as possible. In a rental agreement can be either verbal or written. It doesn't have to be written. Any rental agreement that intends to last for longer than a year has to be in writing to be enforceable. So if you have a verbal agreement that you can stay here as long as you want, but that agreement's not in writing, then the law is going to treat that as a month-to-month rental agreement. But it's still a rental agreement, even though it's verbal. The rental agreement should set out what the rent is, what property is being leased, what the due date for the rent is. Those are probably the three fundamental requirements that you need to have a basic rental agreement. Now, in addition to the rental agreement, there's also the Residential Landlord-Tenant Act. There are also some what are called common law rules, which are basically just rules that courts have developed over time to make decisions in various cases. And that's generally called the law. And the law can fill in certain gaps. So let's say that there's a conflict in your lease agreement about what your rent due date is. Let's say that at one point in the rent agreement, it says your rent is due on the 1st, but then at another point in the rent agreement, it says the rent is due by the end of the previous month. Well, the natural interpretation of that would be that it's due by the last day of the previous month. So there's a discrepancy there. So a common law rule that the courts have developed is that if there's a conflict in terms, or what's called an ambiguity, the courts are going to construe that ambiguity against the drafter of the document. So most often the drafter is going to be the landlord, so the court should find that the due date in this hypothetical scenario is the 1st of the month, since that would be the construction against the drafter. But the Residential Landlord-Tenant Act and common law sort of fill in the gaps when the rental agreement either doesn't address something, or if the rental agreement has a provision that is prohibited by law. So as an example, landlords are required to maintain, to make certain maintenance, or to maintain the property, not entirely, but they're supposed to maintain the big things, plumbing systems, electrical systems. If the door gets damaged or taken off the hinges, that's the landlord's issue. So the landlord often cannot put onto the tenant the obligation to maintain the fitness of the property or to maintain the habitability of the property. The tenant does have obligations, which we'll talk about, but the Residential Landlord-Tenant Act would trump any lease provision that contradicts the Residential Landlord-Tenant Act. So moving along, the first big thing, and of course, one of the primary aspects of the landlord-tenant relationship is the payment of rent. So what rights does the landlord have as respects to payment of rent? Under South Carolina law, the landlord has the right to be paid rent on the due date. However, the Residential Landlord-Tenant Act gives the tenant a 5-day grace period for the payment of rent before an eviction can take effect. The landlord can charge late fees for non-payment of rent, and the landlord is not required to make any number of attempts to collect collect rent. If rent is more than 5 days late, the landlord, in order to have the right to evict, has to provide one notice, and that notice has to say something to the effect of, you have 5 days past the due date within which to pay your rent. If you don't pay your rent within that time frame, the landlord can seek to have you ejected or evicted. That notice can actually be written into the lease, and there's language in the South Carolina Residential Landlord-Tenant Act that the act suggests is satisfactory to that obligation. So a lot of times you will see that notice written, oftentimes verbatim from the statute, into the lease. If it's not in the lease, the landlord has to give a written notice, a letter, once during the entire duration of the tenancy. So the landlord doesn't have to give the notice every time rent is late, just one time at any point during the tenancy. Now, it often occurs that there are rent disputes. Landlord says you didn't pay, or tenant didn't pay. The tenant says I did pay, and there's a dispute as to what was paid, when was it paid, that kind of thing. It is vital for tenants to get receipts. If the landlord refuses to give a receipt, which is something that we hear not infrequently, unfortunately, the best advice I can give would be to keep a ledger. Just keep a piece of paper or anything where you write down the date, the time, the amount paid, the method of payment, whether that's money order or cash or personal check, something like that, especially if you're paying in cash, because there's no way to go back and reconstruct what was paid based on either bank withdrawals, or it's close to impossible. And if that becomes an issue down the road in court, the law says that the magistrate is supposed to determine the issue, but of course the magistrate needs evidence. And so you want to be able to give the magistrate evidence as to what was paid, when it was paid, if it comes to that. So if you can pay it by check or by money order, that's often preferable, because then you'll have a record that you can keep and you can use to reconstruct that payment history. Now, maintaining the property. So this is a double-sided coin. The landlord has obligations and the tenant has obligations.
Hey, Mark, before you get started on that slide, we do have a few questions.
All right.
Go ahead and ask you those. I think some of them might be relevant to some things you've already mentioned. Would that be okay?
Yeah, that'd be great.
Okay. So the first question is, in case, let's see, if the tenant moves out and leaves tools and furniture, can the landlord remove them, and who pays for storage? If that's something you're going to get to later, we can come back to that.
No, there's actually a statute that covers that, and I believe it depends. It depends on the value of the property. Generally speaking, I don't want to say $500 is the dividing line. Of course, if you get a writ of ejectment, then you have from the magistrate court, then you have the authority to go to the sheriff, and the sheriff will actually take the property and put it on the, just put it out on the street. We're going to talk somewhat about the rights of access, but the landlord generally has no right of access unless, either it's written into the lease that you have to give, say 24 hours notice or so, or if the tenant abandons the property. So if the tenant abandons the property and leaves a bunch of stuff in the property, let me see if I can double check. Yeah, so the code section is 2740-730, and it describes the landlord's remedies in the event that the tenant is not using or has abandoned the property. And it refers to another code section about how property above a certain value, it's $500 is the cutoff, generally has to be sold at public auction or auctioned off through the magistrate court. And there's another process for doing that, which is South Carolina Code Section 273710 through 2737-150.
Okay.
Yeah.
The next question is there a limit on the late fees that could be charged?
I think there is, yes. So the concept of, and this is another one of those common law kind of filling in the gaps thing, the courts don't like to enforce what are called penalties. And so if the amount of a fine is not proportional to the extra work or the extra burden of doing something with respect to, maybe the late fee triggers additional collection attempts, or maybe the late fee, causes the landlord to, or maybe the late fee goes to offset some sort of financial obligation that the landlord incurs by having the rent paid late. That makes sense. But you see some contracts where it'll say the late fee is $5 per day or $10 per day or something outrageous. At some point, I think a court's going to find that becomes a penalty, and a court, the case law holds that a court will not enforce a penalty. So where the dividing line is there, it's not black and white, it's a gray area. But I think at some point, a late fee can be unenforceable, at least to some extent.
Okay, and what if the landlord requires that rent be paid in cash and refuses to give receipts? Is there anything that you can do about that?
There is no legal obligation for a landlord to, give receipts. And I guess the flip side would be there's no legal obligation, of course, for, the recommendation would be for the tenant to find a place that doesn't, that does offer receipts. But no, there's no legal obligation for the landlord to do that. So the best advice I can give is get a piece of paper and keep your own list of when you pay and how much you pay.
Okay. And this might be related. Are bank statements sufficient in court to show that money was taken out for rent?
Bank statements are adequate to show that money was withdrawn. The bank statement will not show what it was withdrawn for. Now, you can make the argument to the magistrate court. Say, for example, if you withdraw an amount that is exactly proportional to or exactly matches your rent amount, there's a reasonable argument there that you withdrew that for the rent, especially if it was withdrawn on or around the first of the month. But if you have a random withdrawal amount, let's say your rent's $800 and you withdraw $500 on the 15th, you might claim that that's rent, and the landlord might say, no, I never got a payment around then. And so how persuasive is that evidence? So the bank statement can be useful. It's not the best source of evidence. It can be useful if the numbers, meaning the amount that you're withdrawing, matches up with your rent or is at least close. Maybe you have $50 in your pocket, you withdraw $500 to meet your $550 rent or so. And if the timing of that withdrawal is on or around your due date, it's better than nothing.
Yeah, that would definitely help with the cash requirement and the lack of a receipt. Okay, one more quick one, and then I'll let you move on. What about withholding rent? Do you have the right to withhold rent when your landlord refuses to fix anything?
Generally speaking, no. We never advise tenants to withhold rent. There's a very limited circumstance under which you can withhold rent only to acquire, and in fact, this kind of feeds into this next slide. So at the bottom, it talks about the landlord having the obligation to supply essential services. And essential services are very specifically defined: heat, running water, an operable sewage and plumbing system, operating electrical system. If the landlord does not maintain those items, and you've given the landlord written notice and a sufficient amount of time to make the repairs, or at least start on the repairs, then you can withhold only as much rent as is necessary to obtain the essential service. Now that can get very tricky, and so as a general rule, we advise our clients just to not withhold rent. There are other ways to address that are prescribed by the Residential Landlord-Tenant Act. It prescribes other ways to address the landlord's failure to make repairs, and we can talk about that. Basically, you have to give the landlord a written notice. The landlord then has 14 days to either make the repair, or if the repair is going to take longer than 14 days, to at least start on the repairs. And if the landlord does not do either of those within the 14 days after you've provided the written notice, then you have the option to either terminate the lease and leave. And the law does not consider that a breach of the lease. You have that right. Or you can file a lawsuit in the magistrate's court and ask the magistrate to issue what's called an injunction. An injunction is a directive from the court to somebody to do something. So the magistrate court would be ordering the landlord to make the repair. And the tenant also has the right to actual damages. So damages, broadly speaking, are any economic value that you have lost because the landlord did not maintain the property as required by the Residential Landlord-Tenant Act or by the lease. So that's your recourse if the landlord doesn't make repairs, but don't withhold rent. Certainly don't do that as an initial reaction. All right, so we'll move on. So maintaining the property. Again, the landlord's obligations are set out in 2740-440 of the Residential Landlord-Tenant Act. And generally speaking, the landlord has to make sure that the property is fit and habitable. And that's going to, fitness and habitability definitely describes conditions of the structure. So if there are holes in the structure allowing, access from the outside, rodents could get in. Certainly you have a fitness and habitability issue there. It's also the landlord's obligation to comply with any building codes that the locality has. Those are the two main requirements. The landlord also has a separate obligation to make sure that any appliances that the landlord provides are maintained, and that the landlord provides essential services, which are going to be heat, electricity, plumbing, running water, running hot water, things like that. There are certain maintenance tasks. So one thing we'll see is if you're renting a single family home versus a multifamily property, multifamily generally being a place where at least 5 or more families can live. The landlord is allowed to shift a few of the landlord's maintenance tasks onto the tenant in a single family home circumstance, if they're renting a single family home, but those have to be written out and agreed to by the tenant. So sometimes we'll see leases where the landlord has shifted that burden onto the tenant, and if it's a single family home, sometimes that's okay. So review the statute, section 440, 2740, 440. It lays out what the landlord's general obligations are, and then what some exceptions are depending on the type of property you're renting. So we talked a little bit about this in response to that last question. If the landlord does not maintain the property or does not make repairs that it's supposed to make, again, don't make the repairs yourself and deduct it from the rent. Now, the landlord and tenant can agree that the tenant will make the repairs, but you'd want to have that agreement in writing so that there's no dispute down the road. If the landlord says, I didn't approve that, the tenant says, yeah, you did. We talked about this, and we were perfectly on the same page. So it's ideal to get all these kind of things in writing. The landlord cannot, sign off his obligation to provide essential services. The tenant, if there is an issue, give that written notice. So a lot of times we'll get cases where people will have talked to the landlord or talked to the maintenance man, and it's a verbal communication. That's not good enough under the statute. If the tenant wants to take the legal remedy of either ending the lease or filing suit in the magistrate court, it has to be written. Of course, there's a question of, is an email written? Is a text written? I think it is. There's no definitive ruling on whether a text is considered a written communication. There is an unpublished decision in South Carolina that does call a text a written communication. I don't see any reason why it shouldn't be. I mean, it does the same thing as a letter or an email, and especially if that's the typical form of communication between the landlord and tenant, I don't think the landlord can in good faith claim that there was a lack of notice. So, ideally you want to put it in, in writing on paper, but text and email are probably okay, in my opinion. That's not legal advice. That's just my humble opinion. And then the landlord has 14 days after that written notice is given to either start making the repairs, in good faith, or to make the repair if the door's broken or the lock's busted. That needs to be. It shouldn't take 14 days for that kind of thing to be replaced. And so then at the bottom of the slide, you can see the remedies that the tenant has if the landlord doesn't do those things. Now, the tenant also has obligations. The tenant has an obligation to maintain cleanliness and the safety of the property, take out the trash, just generally be reasonable. That's a term that you'll hear a lot in the law. Are you acting reasonably? You have to follow reasonable rules of the landlord. Also here, kind of circling back around to the first slide, where do the rules come from? So a lot of times properties will have house rules in addition to the lease, and house rules are entirely appropriate, and house rules can actually be updated on 30 days written notice to the tenant. Now, if the house rules materially change the term of the lease, so if they change the rent, or if they reduce the lease term from a year to 6 months, that they can't do those kind of things. But if it's something like we want to change the way in which you request maintenance, that's entirely appropriate. If we want to impose certain restrictions on the use of a general use, say playground or workout facility. That could be a house rule issue, and those can be updated on 30 days notice, even during your lease term. So you have an obligation as the tenant to follow those reasonable rules. You have an obligation to control your guests. So if a guest visits and you've invited that guest over and the guest acts up, that can fall on you. We often get some cases where people will show up and there's a dispute as to whether they're a guest or not. So that does happen. But generally speaking, you're responsible for anybody that you invite over. And of course, the right to peaceful enjoyment means that you shouldn't disturb other tenants and they shouldn't be disturbing you. So.
Okay, here's some other questions.
Sure.
While you're at a pause spot. What about regarding disturbing other tenants and keeping things safe and clean? There's a question that asks about what are your rights if there are issues with your neighbors having cigarette smoke and mothballs and those sort of things, especially where you have allergies that are related to that.
Right. Well, I would first, try to report that to the landlord and see if in the law that's considered a nuisance. If somebody is doing something on their property that is transferring over to your property and causing some sort of hazard, that's called a nuisance. And really the landlord ought to intervene with the neighbor, because you don't really have a legal authority to enforce that contract or to do much about it other than to try to block the odors from coming into your apartment. And if that's not possible, realistically, the landlord should make that, should resolve that. I mean, I think that can actually circle back around to the landlord's obligation to provide a fit and habitable place. Is a property that is filled with cigarette smoke for somebody who has asthma or breathing problems, is that fit? I mean, and so you may think about providing that 14-day written notice that if the landlord doesn't intervene, might allow you to terminate the lease. And you may think to yourself, well, if I terminate the lease, isn't the landlord just going to claim that this doesn't fall under that 14-day procedure? One thing you can do to try to protect yourself is to go ahead and file a lawsuit with the magistrate court, asking the magistrate court to allow you out of the lease. And if the magistrate says, yeah, this falls within that 14-day procedure, you're able to get out of the lease, then I think you're as protected as you possibly can be there. So I would probably employ that 14-day procedure, give the written notice, 14 days, and see if things get better. But before doing that, try to communicate with the landlord, the property manager, and just see if you can prevail upon them to intervene with the neighbor.
Okay, and two other questions. One, I'll go ahead and give you both of them and you can answer them. One is about the quality of the roof.
Mm-hmm.
And then the other one is about stipulations about improvements to the property.
Okay.
Or can the landlord make stipulations about improvements to the property?
Well, if by stipulations you mean can the landlord and tenant agree that the tenant will maintain certain aspects of the property, perhaps. If it's a single family dwelling, the landlord has more flexibility with writing into the lease that the tenant will be responsible, for maintaining, for example, appliances. So if the fridge breaks, and even if the landlord has provided that appliance, the landlord can shift that obligation onto the tenant in a single family residence type situation. As far as making improvements to the property, like building an add-on, there's nothing in the residential landlord tenant code that prohibits the parties from agreeing to the tenant performing major improvements to the property. My question would be, what value is the tenant getting out of that? And, what protections does the tenant have that the tenant's lease won't be terminated, the month after the work is done? There have been some cases in the commercial setting where a commercial entity has made significant improvements to the property, and then the landlord attempts to terminate the lease on what a court considers to be a minor infraction. Maybe the rent's 5 days late or something like that. And courts have, over time gotten less inclined to terminate leases, especially where a tenant has a significant investment in the property over and above just the rent payment. So without really knowing what kind of stipulated improvements we're talking about, that'd probably be my answer. And as far as the roof, I guess is the question to contemplate that the roof is leaking or there's some problem in the roof?
Yeah, it just says, does a roof qualify as one of those services that you were talking about, the essential services?
Yes, the roof is the landlord's responsibility because it goes it goes to fitness and habitability primarily. There's case law that talks about how anything that's the structure, the walls, the ceiling, the structure of the property, that is what is one of the things that is contemplated when the law refers to a fit and habitable property. So,
okay, and let me give you this one last question that has to do with disturbing other tenants. And that is, if you have a neighbor who is playing very loud music, and although your landlord is telling them to keep the music down, they're not doing it, and the landlord isn't doing anything else.
well, you have a right to peaceful enjoyment. So, I mean, one thing you could do would be to file a lawsuit against the landlord in the magistrate's court, asserting that your right to peaceful enjoyment has been violated. That could be compensated by damages, perhaps, and then that would certainly give the landlord an incentive to evict somebody who is violating the right to peaceful enjoyment. Beyond that, if you've tried every kind of talking to and communicating with both the neighbor and the landlord, and there's just nothing working, I think that's probably the only option you'd have left, unless the landlord would let you out of the lease and you could move to a different location, which I know is often offered as an option, but it's not the option most tenants want to take. They just want to be able to stay where they are and have a reasonably peaceful existence. So,
is calling the police an option in that situation?
Well, I'm not a criminal attorney. I mean, I guess there could be a nuisance ordinance that would be violated, so possibly, but I don't want to give any advice on at what point do you call the police on something like that. So, but yeah, I mean, I would check the local ordinance. If it's Greenville County or Greenville City, I'm sure there's an ordinance on noise issues. So that may be a criminal matter as well. All right, well, moving right along, access to the property. So, we often get questions, how often can the landlord, come into the property? The landlord has the right to reasonable access. This is written into the landlord, South Carolina Residential Landlord Tenant Code. So even if this is not addressed in the lease, it's something that the Landlord Tenant Code supplements. The landlord cannot enter without the tenant's permission, generally speaking, unless there's an emergency or if the landlord announces his intent to enter to perform regular maintenance or services that the tenant actually requests. And you can enter with the tenant's consent in other cases, which you have to give 24 hours notice. Now, one thing that the law prohibits, the landlord cannot use the right of access to interfere with and annoy and harass the tenant. So if it's like every 48 hours, the tenant is getting a visit from the landlord, I mean, that could be harassment, and that's not the purpose of the statute. That's not the intent of the statute, and that's prohibited. Of course, the tenant can't change the locks without the landlord's permission. And then security deposits is another thing that we get. Security deposits come up, of course, at the end of the lease term, and the landlord is allowed to deduct from your security deposit the cost of any repairs or damage that the tenant caused, or any unpaid rent or any other unpaid fees that were validly charged under the lease. So, you know, again, ideally you want to get a receipt for what your security deposit was at the time you move in, and you want to take pictures of when you move in, let the landlord know in writing if there are any repairs that need to be done when you move in. Some landlords will do like a walkthrough with you, and there'll be a checklist that you fill out at the beginning of the lease term. And then when you move out, you definitely want to take pictures before you leave, because if the landlord charges you for cleaning the oven and you say, wait, I really scrubbed that thing down, and there's no proof, you know, it's a difficult case to make. When you move out, you want to provide the landlord with a forwarding address. The landlord then has 30 days, and you want to request the security deposit in writing. Then the landlord has 30 days to provide the security deposit or provide what's left over after deductions. And if any deductions are made, the landlord has to itemize what deductions were made. They can't simply say cleaning. It should say, you know, $150 cleaning the carpet, you know, $60 cleaning the fridge, something like that. It should itemize the exact deductions involved. And of course, for the landlord wants to protect itself and to be able to determine what damages were tenant caused versus what damages were pre-existing. So pictures at move in and move out are ideal. You know, if the landlord does deduct an amount that the landlord is not allowed to deduct, then the tenant has a cause of action for 3 times the amount wrongfully withheld plus reasonable attorney's fees. You know, so let's say, you know, the landlord only withheld $50. Well, that $50 could turn into $150, and then if the tenant has an attorney litigate that case, that could be, you know, another $1,500 or whatever the cost of that attorney's fees are. So it can get a little bit pricey. So be careful about that what you deduct actually is permitted by the Residential Landlord Tenant Act or the lease, and that it was actually for stuff that ought to be deducted for. And then the final point just gives the timeline. So it's 30 days generally after the tenant moves out and asks for the money back and gives a forwarding address. That's the key thing, is that the tenant needs to provide a forwarding address for those security deposits. And then just a sort of general tip, this doesn't really have anything to do with the law, but renter's insurance, it's really cheap, and you know, the landlord is not responsible for replacing the contents of the apartment. If the apartment burns down, the building, the landlord's insurance policy will cover the reconstruction of the building, but it won't recover replacement of the items that you own. And of course, roommates, you know, you can split the costs, but if you have a roommate that acts up, that doesn't act right, their actions can have a fallout on the entire unit, everybody who's living in that unit. So just be wary of that. Now
we'll move on. More questions before you get into terminating the lease. We do have a few more. One is, what if the landlord doesn't give the required 24-hour notice and it's not for repairs? That's, I guess, not paying the rent.
Right. Well, for the violation of a legal duty, there's usually a cause of action. The question really is, what is the remedy for that? You know, damages, which is monetary damages, is the traditional remedy at law that somebody would get. So what is the cost, you know, what is the monetary value of somebody entering your property without permission and invading your privacy? I don't know. There's no case in South Carolina that discusses that question, but it's worth something. You know, is it worth $5,000? Maybe not. Is it worth $50? You know, it's probably worth a little bit more than that. So you may be able to bring a lawsuit for damages, or a lawsuit asking the magistrate to enjoin the landlord from doing that. In cases where we see allegations of unauthorized entry, we run into a lot of issues of proof. What's the proof of that? You may suspect that somebody has entered, something may be misplaced, maybe, I don't know, something on the counter seems to be have moved somewhere else. But is that, when we look at it as a lawyer, we think, okay, is a magistrate or a jury going to be convinced that this actually happened? So we run into a lot of issues of proof there, and you just want to make sure that you can prove what the allegations are.
Okay, and when you refer to the landlord, will that also include, by extension, someone doing repairs, like a plumber or another repair type of subcontractor?
Yeah, I think anytime the landlord or the landlord's agent or contracted agent, in this case, enters your apartment, you are entitled to the notice. You have a legal entitlement to that notice. The remedy of what's the consequence of somebody not living up to that notice, that's a bit less clear and may not be as strong and forceful as a tenant may think is necessary. But I mean, you do have a legal right to at least 24-hour notice. Of course, if you ask the person to come over and make the repair, that may be a different story. But if it's out of the blue, unknown to you, that shouldn't be happening.
Okay, there's a couple more questions, but I think they do apply to eviction, so maybe we can wait until after you have
Yeah.
I'll do your next step for those.
If this answers any of those. So eviction is really a two-step process. You can think about it. First, the landlord has to end the lease or terminate the lease. Then, if possession has not been granted at the end of the lease term, or when the lease is terminated, if the tenant does not vacate the property voluntarily, then the landlord files an eviction action to regain possession of the property. But you always have to terminate the lease first. And what do you have to do to terminate the lease depends on why the lease is being terminated. If you're on a month-to-month rental situation, you have to give a 30-day written notice that the lease is not going to be renewed, for the next 30-day rental term. If the lease is being terminated for non-payment of rent, you have to give that 5-day notice either in the lease or as a separate notice if it's not written into the lease that we talked about earlier. So you have to give some sort of notice as to, and it depends on why the lease is being terminated. Then if the tenant does not vacate the property, you would file an eviction action in the magistrate court, and the magistrate court will issue what's called a rule to vacate or show cause. The magistrate's constable, typically the constable, will serve that rule to vacate on the tenant. The rule requires personal service. However, if the tenant cannot be located after 2 attempts, then it can be mailed to the rule to vacate or show cause can be mailed to the tenant. And the tenant will have 10 days to request a hearing. The magistrate can hold a hearing. If the tenant loses, the magistrate will issue what's called a writ of ejectment, and the tenant can be forced to move out, and the sheriff can just physically displace, put the property outside if that doesn't happen. So just to get into a little bit more detail, the non-payment of rent, we talked about how the landlord has to give the 5 days written notice unless it's written into the lease, and it has to be given once per lease term. Breach of the rental agreement often has to give, the landlord often has to give a 14-day notice that the lease will terminate. And if the tenant does not fix the problem, so South Carolina is what's considered a right to cure state for most things. Cooking meth on the property, you don't get a 14-day right to notice on that. But for most things, you do have a 14-day right to cure. So a noise complaint, an unauthorized guest, things that are not really threatening the health or safety of the premises, and things that are not otherwise illegal, get a 14-day right to cure before the landlord can file an eviction against the tenant. So that 14-day notice should say something to the effect of, we've noticed that, or landlord has noticed that you've been doing X, Y, or Z that violates this provision of the rules or of the lease agreement. You have 14 days to, you should either not do that again, or 14 days to, repair the hole that was put in the wall, something like that. And if you don't, we can seek to have you evicted. And then after that, if the repair is not made or the issue is repeated, the landlord can move forward with eviction. So in South Carolina, the lease can end and nobody is required to renew it. And at the end of a lease term, if a lease term is spelled out in a lease, say for example, 1 year, the lease term ends automatically. Now, if you're on a month-to-month situation, there's a statute that says that lease term renews until it's terminated, but it's different for longer lease terms. Those lease terms end at the end stated in the lease, unless it's been renewed. So it's a little bit different treatment. And the landlord does not have to give a notice to terminate a lease where the end of the lease term is specifically stated in the lease. Now, if the lease term ends, let's say it's a year-to-year lease starting out, and the lease is not renewed, but the tenant keeps paying and the landlord keeps accepting rent, and we're 3, 4, 5 months down the road, the law would treat that as a month-to-month lease at that point. So, of course, if the tenant abandons the property, the landlord is allowed to terminate the lease. And in the case of abandonment, if it's really true abandonment, the landlord does have a right to retake the property without going through the judicial system. But generally speaking, the landlord does not have the right to a self-help eviction, which is what it's called when the landlord unilaterally regains possession of the property without judicial process or approval. So after the lease term is evicted, or after the lease is terminated, the landlord can move on to eviction, and the tenant will be served with the rule to vacate or show cause, after which the tenant has 10 days to respond. I would say here, a lot of cases we get, the tenant will have gotten the rule to vacate and will have automatically called the magistrate. And at that point, the magistrate will schedule a hearing. I would say maybe wait, and if you want to seek out legal counsel, if you can seek out legal counsel, you should do it before responding to the rule to vacate. You don't want to miss the 10 days. So if you're at the end of your 10-day period, call and get the hearing scheduled. But if you're early in that period of time, either call legal services or call the bar referral service. So because you may have defenses, you also may want a jury trial, which you have a right to. And if you don't make some of those requests or put those defenses in writing timely, you may forfeit them. So for example, with the jury trial, if you don't request a jury trial in writing 5 business days prior to the date that the hearing is set, then you lose it. So if you call the magistrate court after you get the rule to vacate and the magistrate court says, all right, well, we're going to have this hearing 3 days later, you don't have 5 days. And so you've waived the right to a jury trial at that point. So I would say seek legal counsel before contacting the magistrate court rather than after. And it's always better to file a response in writing. That way you can kind of collect your thoughts, write down why the eviction ought not to go forward. The magistrate will be able to refer to what your arguments are going to be, and you'll be able to refer to what your arguments are going to be at the magistrate's hearing. And then the court's going to schedule a hearing after you respond. If you don't respond, the court's just automatically going to issue the writ of ejectment, and that can be served, and the property can be dispossessed within the time allowed by law, which is really short. If you do have a hearing and the court decides against you, the court will issue the writ of ejectment. That is supposed to be delivered to you and posted at the property, and then at a minimum, 24 hours after the posting of the writ of ejectment is when the sheriff's deputy is legally authorized to come back and dispossess the tenants from the home. If you're dealing with elderly or disabled tenants, the statute says that the sheriff ought to exercise discretion in exercising or executing the writ. So you may maybe get a little bit more time if you're elderly or disabled but it's not a lot. So if you do have a writ of ejectment coming up, moving things into storage might be a reasonable idea at that point. And also, this doesn't really cover it, but there also is the right to an appeal. You would file an appeal if you believe the magistrate made the wrong decision. You would file your appeal at the circuit court. Now, there's a whole process to go through for doing that. So, and I don't think that we really have the time to get into it now. But just know that you do have the right to appeal. If you're being evicted because, let's say, you were accused of breaching the lease by having an unauthorized guest, and you believe that the weight of the evidence failed to prove that you had the unauthorized guest, you can take that up to the circuit court and let a circuit judge decide that issue on appeal. Just one more thing on the appeals. If the issue is non-payment of rent, there's a statute that requires you to bring the rent current and to keep the rent current while the appeal is ongoing. So that may be an insurmountable barrier in some cases where the issue is non-payment of rent. Because South Carolina law says that even if you do end up bringing the rent current, let's say you bring the rent current 2 months later, the right to evict doesn't go away. So you could find the situation where you bring the rent current and still get evicted, which would be terrible. But just some things to think about. So with that, I'll just leave you contact information, and I'll take any other questions that anyone might have.
Okay, we do still have some questions coming in, and there's a few minutes left. So one question is, can a landlord post an eviction notice on your door after you go to work and then throw your things out into the street the same day? It does say eviction notice and not ejectment. So
yeah. Well, I'm going to assume that means the writ of ejectment. So the landlord is not supposed to be posting the writ of ejectment. The sheriff, the sheriff should be posting it. And then they have to wait 24 hours. If they don't wait 24 hours, that's unlawful. And you'd have a remedy, perhaps for damages, trespass to your property. I mean, you have the 24 hours after the writ of ejectment is posted. Now, if an ejection notice is simply just a letter from the landlord saying, if you're not out by 5, I'm going to come in and remove everything, that's clearly unlawful. That's called a self-help eviction, and it's not permitted in South Carolina if the tenant has not abandoned the property.
okay, and let's see here. What about if you are, when you move in, the home is dirty and damaged? Is it reasonable to have to return the home to the landlord in a cleaner condition than when you came in, as far as being cleaned and repaired and so forth? Is it reasonable for them to request things that were not done when the home was initially turned over to you when you first rented it?
Right. So, if we're talking about there's a hole in the wall or the light switch doesn't work and you return it to them and they deduct something from your security deposit to repair those items, that's not proper. It gets back to proof. What's the proof of, if you're going to pursue an action in court, what's the proof of what the property condition was at the beginning versus at the end? Again, the tenant has the right to clean the home. So if we're talking about, dirt and grime, that may be in under the tenant's obligation. I think what the tenant ought to do at the outset is, if the property is not delivered in a clean or fit or habitable condition, I think from a legal point of view, you'd want to require the landlord to do that at the time you move in. And if they refuse, then move elsewhere, because you're not getting what you expected. You're not getting your expectancy rights under that lease agreement. I rented a fit and habitable and clean house from you. But after you sign the lease, after you enter into an agreement to rent property, a presumption, especially as it relates to cleanliness and things that are not clearly the landlord's obligation, there can arise a presumption under the law that you agreed to accept the property in the condition that it's in. And then at the end of the lease, if the landlord is charging you for cleaning something that was never clean, I don't know, I could see that going either way, perhaps depending on what magistrate court you're in, what kind of jury you pull. Yeah, that's a tricky situation sometimes. But if it's things like holes in the wall, leaking roof, no, that's the landlord's obligation.
All right, and if you don't have pictures, can you still tell what the condition was like?
You can, yeah. And then it's going to be an issue of credibility. So your explanation and your description of what the condition was is perfectly valid evidence in a court of law, but the assessment you have to make is the magistrate or the jury going to believe what I say? And the way to make yourself more credible, or the way to be more credible, is to be more specific. So the more, instead of saying the place was dirty, you could say the refrigerator had mold in the freezer on the top left shelf. I mean, the more specific you can be, the more, the easier it is for a listener to understand what you're talking about, first of all, because that's what you want to be able to convey, that image, that mental image, to the judge or the jury. And so the more specificity you can muster, the better. And it also makes your story appear more credible, because we have plenty of people who may have entirely credible stories, but they can't express it well enough, and so you just know it's going to come across as it's not going to be very persuasive. So that's a problem we run into, and which is why pictures are wonderful if you can take them. But if you don't have them, try to be as specific and detailed as possible.
Okay, what if you have paid your rent for a few months ahead of time, but then you have to unexpectedly move out? Is there anything that you can do to get a refund of unused rent? Obviously, unless your landlord agrees to it.
Right. So basic contract law would provide that you're entitled to what you pay for, and if you pay for more than what was given to you, you're entitled to some refund. So prepaid rent, in addition to the security deposit, any prepaid rent ought to be sent back to you as well. So if the landlord does not return the prepaid rent, you'd file a lawsuit in the magistrate court asking for the magistrate to enter a judgment against the landlord. And hopefully there wouldn't be much in the way of numerical disputes about what was prepaid rent and what was rent for some period of time where you actually in fact lived there. That would be probably the dispute that I can imagine coming up. But if it's truly prepaid rent that you never drew down, yeah, you're entitled to that back.
Okay, and then sometimes utility companies won't tell you if the power is on or off, citing privacy rights. So do you have any tips on determining if the utilities are off?
I'm not entirely sure. So my first thought is, wouldn't you be able to test them? And if they don't turn on, or if the water doesn't turn on, is that not an indication that the utility is off? So I don't quite have enough information to be able to answer the question.
Okay. Well, maybe the questioner can give some more information. What are your rights if you miss the hearing and a writ is obtained?
So the only two things you can do, well, if you want to appeal, you have to have what the law calls a record. A record is just whatever happened at the hearing. And if you don't have a record, then there's nothing that you can appeal on. You can think of a record as like a vehicle that's going to get you from point A to point B. Well, if you don't have a record, you're not getting from point A to point B, so you can't appeal. So what you really need is you need a new hearing. And The magistrate court rules allow you to ask for a new hearing. You can file what's called a motion, which is basically just a written statement, explaining why you need a new hearing. You need to have a good reason for why you missed the last one. And you can file it within 5 days of the date that you are notified of the writ. 5 days of the notice of the judgment is what the statute says, or the rule says. And you can ask the magistrate to grant you a new hearing. But they don't just grant hearings just because. I mean, there has to be, sickness, car accident, some sort of just impossible situation where you can't be in two places at one time.
Okay, going back to utilities, this is in regard to on behalf of the landlord, if the tenant has potentially abandoned the property and you can't enter without notice and you can't check, that whether or not the utilities are on or off, because the tenant's rights are the ones that are, private.
Right. I think the statute, let me double check it here. I think it basically says that non-paying rent for 15 days raises a presumption of abandonment, is my thinking here. Let me just double check. Yeah. I believe that's right. Let me look that up. Or actually.
Okay. Well, while you're
Yeah.
that up, just in case you can find a quick answer.
Yeah, and I just it's part of the presentation. So an unexplained absence for 15 days after default in payment of rent constitutes abandonment under the residential landlord tenant code. So,
Okay.
they don't pay rent, wait 15 days, and then you would have the right to treat it as abandoned.
Okay. And this is probably beyond your presentation for today, and we are over the time. But if you have any resources for this person who asks, what are the requirements for becoming a landlord? And I know there's a lot of rules and regulations and laws to follow, so I think that's outside the scope of today.
Yeah, that's going to depend on a number of things. If you want to become, say, for example, a landlord of like a housing choice voucher program, federally subsidized property, there's, the public housing authority for your area ought to have a list of requirements for becoming a landlord of a housing choice voucher tenant. Municipalities, for example, I know Clemson has a rental ordinance, so your local codes office may have knowledge of an ordinance. You may have to get a permit or have some sort of inspection to make sure it's fit and habitable. So the South Carolina Residential Landlord Tenant Act does not speak to what you need to do to become a landlord, but either the municipality where you live or the public housing authority, if you're trying to become a subsidized housing choice voucher landlord, would be two sources I would check out.
Okay, well, Mark, I want to thank you so much for your wonderful presentation today on Rent Smart, Basic Landlord and Tenant Rights in South Carolina. That was an excellent presentation, and I know that on our various resources on our websites at South Carolina Legal Services, there are a lot of other resources beyond the things that you discussed today. And I would just mention that those are our main website at www.sclegal.org, and also a lot of helpful resources at lawhelp.org/SC, where most of our legal resources are maintained. You can also, of course, visit our YouTube channel where a lot of the videos are housed. So, Mark Fessler, Housing Law Unit Head, that was a wonderful presentation. I do want to remind our listeners that they will receive a copy of these slides as well as a recording of today's presentation. And also, I want to remind you that we have Level Up Law every Tuesday at noon. And next Tuesday, June 30th, we will be talking about Keep It Simple, Elder Law 101, and that will be with our Elder Law Unit Head here at South Carolina Legal Services, Taylor Ott. So thanks everyone for joining us. And again, Mark, thanks for a wonderful presentation.
Thank you, Susan.